much for being here tonight. I'm Christy with the Ark of Grace Harbor, and we're so pleased to have attorney James Brown here. He's an elder and disability law attorney with offices in Aberdeen. He received his Juris Doctor degree from Western State University College of Law in 1978. He's a member of the bar in both California and Washington. He's the managing partner at Phillips, Krause, and Brown. His practice emphasizes elder law, which includes life care and estate planning, Medicaid planning and qualification, preparation of wills, trusts, including special needs trusts and D4A trusts, durable power of attorney and other planning documents, probate, guardianship, and litigation in those areas. Thank you so much for being here to present to us tonight.
Well, I'm happy to do that. I guess I will try to share my screen now, and we will see if it comes up, and
it does.
Yeah.
I think we can see that. Okay. So no presentation about the law would be complete without a disclaimer. So just so everybody knows, we're not practicing law. I'm not practicing law with you tonight. You're not my clients tonight. That might change sometime in the future. It's important to understand that legal advice in any area of the law, especially estate life care planning, and we're talking about guardianships as well, depends on individual facts, the people involved, and can only proceed if there's been a clear lack of my phone ringing in the background. Sorry about that. It'll probably keep going. We ignore that phone. Anyway, let us move on. Here's an overview of what we will cover. First, a little bit about generally what guardianships are, because we're going to talk quite a bit about a huge sea change in the law of guardianship with the advent of the Uniform Guardianship Act. So some general considerations, and then a discussion of where we stand right now with the current law that's, except for minors, is going to go into effect later on in 2022. And then we will discuss the Uniform Guardianship Act, also known as the UGA, as it's been adopted in Washington. It is in effect right now for guardianships of minors, which might affect somebody on this webinar. But the act as it pertains to adults does not go into effect until 2022. And then after we've gotten through all that, we will have some time to talk about alternatives to guardianship and why it might be important to find some alternatives. The Uniform Guardianship Act makes an awful lot of major changes, both in policy and the implementation of guardianship law in the state of Washington. For that reason, there have been an awful lot of other lawyers who've been studying the act, who have taken it apart and put it back together. But I do want to make certain to recognize a few of the people that have had a lot of input that seems valuable to me. Sage Graves is an elder law attorney in the Bellevue area with Hickman and Minaj. Amy Friedman is the attorney for the Washington Long-Term Care Ombudsman, and Patricia Hunter is in fact the Washington Long-Term Care Ombudsman. David Lord has been, I think he's retired just recently, but he has been the public policy director for Disability Rights Washington. And Kay King is a senior program analyst and training coordinator for guardianship at the Washington Office of Administrator of Courts. And the Washington Administrators of Courts has a special guardianship section that's charged with the overall state input and, in some ways, administration of guardianship law in the state. So Kay King has had an awful lot to say and suggestions that I've drawn on as well. So, guardianship, we first have to recognize is a court process. There is no guardianship unless a court has made a decision about whether somebody is capable of managing their own affairs. In olden days, we used to talk about whether somebody was competent or not, but that kind of thinking has gone the way of the, well, I'm not going to say the dodo, but because that's unfair to dodos. But the concept now is based on capacity, whether a person has the capacity to make good decisions regarding themselves, their health, or their property, or if they become susceptible to fraud or undue influence, such that they need to have supervision in their lives in order to keep them safe. Now, the real downside about guardianship is very much like criminal law. It removes rights. It takes away the rights of a person under a guardianship. And that's the reason that it should really be considered the last alternative in trying to help somebody. Now, our current statutes, which apply to adult guardianships, and we're going to talk about guardianship of minors shortly, but for adult guardianships, the rules are contained in 2 chapters of the Revised Code of Washington. So chapter 1188 is where it talks about appointment of a guardian, the process for getting a guardian appointed, the notices you must give, the investigation that's done, the people who do that investigation, and finally, the hearing and appointment of a guardian or a limited guardian. And in Washington, we have for many years had limited guardianships where if somebody needed some help but did not need a full guardianship, a limited guardianship could be appointed, a limited guardian could be appointed to take care of those areas where there's a need and leave rights with the individual where they do not need help. Then chapter 1192 is the administration of guardianships. What are the duties and powers of the guardian? What reports do they have to make? When are those reports due? And what happens if a guardian is not doing what's right? And how do you get a guardian removed? So there are those 2 chapters. A criticism of our law was that it was a little disorganized because over the years, we have come up with many different areas that need to be addressed by our statutes. And while we've cleaned that up a little bit, in many areas, there was a little disorganization. That's one area where the Uniform Guardianship Act does give some help. And it is quite well organized, whether we agree with it, with what it says or not. So if we're going to look at guardianship, we should talk about when somebody might need a guardian. And it's primarily if somebody has difficulty in making sound decisions that are going to keep them safe, whether that's about use of their property or getting health care, taking care of themselves. Critical to this discussion is whether there's been pre-planning. If somebody has already established a plan by using a durable power of attorney or has appointed an agent to help them with their finances, there might not be a need for a guardian. And if there is a need for a guardian, it may be just a limited guardian. So guardianships are not the best way of handling things if they can be avoided, because they are often quite expensive and time consuming, especially if there's a fight. They become emotional and expensive and contentious. I should also mention that if there's been no pre-planning for medical decisions, and there are other kinds of healthcare decisions, but for medical decisions, if no one has been appointed formally by a patient, then we do have a statute for what's called surrogate decision making, where somebody, if they are in a close relationship with the person, and recently we amended that statute, our CW 770065, we amended in order to allow even somebody, if they're well-intentioned and are a friend or just have knowledge about what would be in the best interest and what the patient may want, they may be a person who would be allowed to make a decision. But you can probably figure out trying to decide whether somebody is in a close enough relationship to make that decision, or whether even if they are a spouse or a child, whether they're going to make the same decision that that person would have wanted. That's kind of up in the air. And it would be much better if everyone had designated what they want done, for example, in a durable power of attorney or a healthcare directive. Now, in a guardianship, we have players. So the first player is going to be the petitioner. The petitioner is a person who asks the court to have a guardian appointed, and hopefully they have a discussion with a lawyer about how to do that and whether to do that, and whether there is some other alternative, some less restrictive alternative to a guardianship. But we have the petitioner, and then we have what we currently call the alleged incapacitated person. That's the person for whom a guardianship is being sought. So as soon as a petition is filed for guardianship, you have a person identified as the AIP, or alleged incapacitated person. Now note, as it says in the headline for this slide, that there are many changes to these terms in the new UGA, in the Uniform Guardianship Act. So this is the language now, but it will change. Likewise, once a guardian has been appointed and there's an order appointing a guardian, then the AIP changes to the IP. They are now designated an incapacitated person. And this term in particular is one that folks promulgating the Uniform Guardianship Act do not like. And I have my own problems with it as well. And as you'll see, we've changed that term in the Uniform Guardianship Act. So the petitioner, the AIP or IP, and then the proposed guardian. And note that this can be either a lay guardian, that means an ordinary person, or we have a class of folks called certified professional guardians. And certified professional guardians usually need to be appointed if somebody is serving more than 2 people as guardian. And then there's the guardian ad litem, the GAL. That's what GAL stands for, guardian ad litem, who's an investigator appointed by the court to investigate, gather information, make recommendations and reports back to the court. There can be a lot of other people involved in guardianships, interested family members. I've been involved in cases where there was the AIP, there were children, there was a spouse. They all had their own attorneys. There might be an attorney, in fact, who's not related, and they appear in the guardianship. There may be trustees of trusts that appear in the guardianship, and just about anybody who has a relationship with the alleged incapacitated person might end up in court. What kind of conditions, incapacitating conditions, might require a guardianship? Well, in my practice, we've had a number of families where there's a child with developmental disabilities, or it might be an older adult who has Alzheimer's or some other form of dementia, or severe Parkinson's, or Lou Gehrig's disease, or alcohol-related dementia, and so on. We've also done guardianships where there was a victim of traumatic brain damage, maybe a severe auto crash, and somebody suffered a closed head injury, and as a result, brain damage. There have been a number of folks come through our practice with psychiatric problems, whether it's bipolar or some other chronic psychiatric illness, alcohol and drug abuse. Victims of drug abuse can often require guardianship eventually. Extreme health problems that keep a person from managing their own affairs, and just the plain inability to make decisions that are in their best interest. Pardon me just a minute. So what happens to get a guardian? What's the process? The first thing that happens in the court is that someone files a petition. And under our current statute, if you are not a certified professional guardian, then you are supposed to also have a training certificate filed at the same time. So there's an online training program through the Office of Administrator of Courts, that same organization I talked about at the beginning. And it's all online. And after a lay guardian has taken the training, there is a certificate that you can print out, and we file that along with the petition to appoint the guardian. If it's a certified professional guardian that's going to serve, or if we've not made a decision as to who the guardian will be, then we don't file a training certificate at that time, and we have up to 90 days to make that decision from the time the petition is filed. Generally, at the same time that we file the petition, we ask that a guardian ad litem be appointed. And if it's an attorney who is representing the petitioner, then the attorney usually draws up an order and presents an order appointing a guardian ad litem at the same time that they take the petition to court. Of course, these days with COVID, we're not really taking our documents to court. We're sending them up by mail, and then we'll have a conference with the judge if there's a question about the contents of the petition or the order appointing a guardian ad litem. Now, once the guardian ad litem is appointed, they meet with the alleged incapacitated person. They usually are the ones who provide the notice of the guardianship and what rights they may lose. And we'll talk about that in a minute. And then the guardian ad litem performs their investigation, which includes an obligation right now to obtain a medical or psychological report. And I don't know, as I sit here, I don't recall whether later on I talk about this point, but one of the changes with the new law is that under the Uniform Act, guardians ad litem are not going to be required to obtain a report, and the judge can waive it. And some of us don't think that's a very good idea. And then the guardian ad litem actually prepares their report, and some of the important things in the report are a recommendation as to whether the least restrictive conditions can be met without a guardianship and whether there are any alternatives to a guardianship. Then there is either a hearing in front of a judge or there's a jury trial, because you have a right in the state of Washington to a jury trial on whether guardianship should be imposed. And as I say here, that hearing or trial is supposed to be within 60 days of filing. In my experience, that rarely occurs, and it's even more difficult with the current COVID problems, such that I don't think there are too many guardianships that are getting heard within 90 days right now. Then after the hearing, the court will enter its order, and it will make specific findings of fact. What are the facts that justify guardianship? What are the limitations that should be placed on the now IP, the incapacitated person? And what are the duties of the guardian? There are duties set forth in the statute, but there are also additional duties that a guardian may have to fulfill. Then once the court has entered its order, the guardian needs to prepare some reports. So there needs to be an inventory, there needs to be consideration as to what the needs of this particular person are and how the guardian is going to meet those needs. Now, just so you know, this is just copied from the actual notice that is given. And it's important to know that a person under guardianship may well lose the right to marry or divorce or vote or hold elective office or make a contract or make a will or revoke a will or be sued other than through a guardian. That's one of the benefits of a guardianship, that if somebody under a guardianship, once the guardianship order is entered, if they do something that's really strange or we might say crazy, then entering into a contract, if you are an incapacitated person, that contract will be set aside, at least if the right to contract has been taken away in the order. You might lose the right to own or lease property or to consent to medical treatment. Now, if somebody can make a reasonable judgment as to what medical treatment they want done, under our current law, they're going to be able to make that decision, even though there may be some limitation on that right. Under the new UGA, it's not quite so clear. Also, the guardian ad litem will advise the incapacitated or alleged incapacitated person of their rights, that they have the right to a lawyer, that if they can't pay for a lawyer will be appointed for them. Doesn't that sound similar to criminal law, that they have the right to ask for a jury trial, that they have the right to be present in court at all stages of guardianship, and that when a guardian ad litem is appointed, they have the right to request the court to change the guardian ad litem. That doesn't mean the court will, but they can certainly ask. So that's kind of a summary of guardianship law as it exists under RCW 1188 and 1192. Now, the new Uniform Guardianship Act in Washington is a huge document. It runs hundreds of pages. So we're not going to be able to go over every single part of it. And there's a great deal of it that no one is quite sure how it's going to work yet, because Washington is only the second state to adopt it and the first state to adopt the guardianship of minors portion of the act. Now, the new act is contained at RCW chapter 11.130. It completely repeals and replaces 1188 and 1192, and in particular, guardianship of minors, which right now is in the non-parental custody portion of our domestic relations laws. Interestingly, our legislature chose to impose the newest part of the Uniform Guardianship Act, the one that is not in effect in any other state right now. It's in effect as of January 1 of 2021. It's known as Article 2 of the Uniform Guardianship Act. The guardianship of adults is replaced. Sorry, there's a spelling error I see. It's not January yet. I think that's some other month. I really don't know. It repeals and replaces guardianship of adults. So all of 1188 and 1192 effective January 1 of 2022. And as I note, it's a broad, comprehensive change in guardianship law, many sections of which are going to require further clarification, I'm afraid mostly by the courts, but probably other additional legislative changes. Now, a little bit about the history of the Uniform Guardianship Act in Washington. This act was first proposed by Senator Jamie Peterson either in 2017 or 2018. I think it was formally brought to the legislature in 2018. Senator Peterson is Washington's ambassador, if you will, or representative to the Uniform Laws Commission. And that's a commission composed of a lot of legal experts and others who try to formulate uniform laws, with the idea being that the laws in the 50 states ought to be closer together than they have been. And I guess the feeling that if you go from one state to another, the laws in each state should be very much the same or at least similar. So Senator Peterson proposed the Uniform Act that had just been formulated by the Uniform Law Commission. They had had a previous act, but it had not been adopted in very many states, and they completely reworked it. After it was proposed, there were a number of stakeholder meetings. I participated in many of those, and the other folks that I mentioned earlier on participated in many of them. I will tell you that Amy Freeman of the Washington State Ombudsman Office was instrumental in gathering the thoughts of all of the different participants. The Washington Academy of Elder Law Attorneys, I happened to be president during 2021, as well as the Superior Court's Judges Association and a number of other groups opposed the Uniform Act because we thought that Washington had one of the most person-centered, best sets of statutes, and we had continued to revise our statutes to reflect modern thinking about guardianships. One little example is that in the 2017 legislative session, just before the Uniform Guardianship Act became an issue here, we had clarified the rights of incapacitated persons to associate with one another. There were nursing homes where some folks were being kind of held incommunicado, and we felt that was wrong. There were a number of court cases, some famous ones, the Casey Kasem case, sort of spurred on our desire to change the law. And so it's just an example, but Washington was really on the forward edge of guardianship law, we felt. But, and the only other state who has enacted any part of the act is Maine, and they enacted most of the act, but did not enact guardianship of minors under the Uniform Guardianship Act. A little more about the history. There were a lot of comments made about the problems we thought the UGA had. And as a result, there have been a lot of changes made to the Uniform Act. So Washington did not has not adopted the Uniform Act exactly as it was promulgated by the Uniform Laws Commission. Importantly, we had two trailer bills, bills that revised the provisions of the Uniform Act. Substitute Senate Bill 6287 was the last one. And in February and March of last year, it made a whole many changes to the Uniform Act. An important part of those changes is that the Uniform Act was postponed from 2020 to 2022. And the Uniform Act was made effective now. The Adult Uniform Act has a lot of provisions, and we'll see just a few of those, that courts need to address and need to think about before 2022. And I believe the legislature felt that they needed more time to look at those. Why they didn't postpone the Uniform Act for minors, I'm not really sure. An important thing that the substitute Senate bill did was to get the mandate for the least restrictive alternative placed into our act. The idea that we should use the least restrictive means of taking care of people who need a guardianship has been at the center of Washington guardianship law for decades. But when the legislature enacted the Uniform Act, they left this out, and they seemed to do it intentionally. But when we were able to get before the legislature again, substitute Senate Bill 6287 brought this back. And it really is critical because it forms the main policy basis for guardianships in Washington. But now they added it at the very beginning of the act. So it's become subsection 001 of RCW chapter 11.130. And it does apply to guardianships of minors as well as guardianships of adults. Some other important changes were that notice requirements were imposed on guardianships for minors. There really weren't such notice requirements. It added provisions for temporary restraining orders and injunctions in minor guardianships in order to protect minors. It set a capacity standard as a basis for guardianship rather than incompetency. One thing it did that we are concerned about in the act as it was adopted, there was a provision for emergency guardianships. While that was revised, it's still possible in Washington, or it will be possible in Washington, to have an emergency guardianship where a guardian is appointed without notice, but they will have to give notice within 48 hours. Pardon me, as my throat continues to go a little dry. We did get some expanded provisions for supported decision-making and a change in the powers of a conservator with regard to real property, and there were a lot of other clarifications. Now, here are some changes, and I told you, I think earlier, that there were going to be changes in the terminology. Well, we still have guardianships for people. In the old law, we had guardians of the person or guardians of the estate. But now if it's a guardian of the person, it's simply going to be a guardian, because there is no longer a guardianship of the estate. Guardianship of an estate now is called a conservator. But there are some differences in the powers and obligations of both the guardian, what used to be guardian of the person, and conservator. They're not the same under the new law. And that person who investigates for the court that we called guardian ad litem is now called the court visitor. We don't call them a guardian ad litem anymore. Now, unfortunately, in the new law, there is a guardian ad litem, but they're not the same as what a guardian ad litem is under our current law. And maybe you begin to see how confusing this might be for a lot of people. The court visitor generally does the investigation now, but after a guardian has already been appointed, the court may appoint a guardian ad litem to help sort out particular problems. So the office of guardian ad litem is very different under the Uniform Act. Also, under our current law, we have what are called standby guardians, so that if a guardian has a problem and cannot address the needs of the person under a guardianship, then the standby guardian can immediately come in and take care of those duties. Now, under the new act, we have agents, special agents. These aren't guys that carry a badge and a gun. These are people that are appointed by the court to try to take care of things if a guardian is not able to address the needs of the person under the guardianship. And we have a new emergency guardian or emergency conservator. These are folks I was, I think, referring to a little bit earlier, that can, when there is no guardian at all, can immediately step in as a guardian, but without notice to anybody except the person under the guardianship for up to 48 hours. And a lot of damage, in our view, can be done in 48 hours. Nevertheless, that's where that sits today. A standby guardian under the Uniform Act is not mandatory, and it's only mentioned in guardianships for minors. Under the old law, the standby guardian that I was talking about before was mandatory. When you appointed a guardian, the court had to appoint a standby guardian as well. Another change is that instead of letters of guardianship, the document that gives the guardian or the conservator powers are called letters of office, but the form that's recommended still mentions guardianship. So I think until they get that sorted out, there are going to be some concerns by people who get that document. If you say to somebody that you're the conservator of the estate or the guardianship of the person and show them that piece of paper, I'm not sure that many folks will be familiar enough with the law to be able to recognize that. And then I was talking about the special agent, that's somebody appointed by the court to preserve, protect, or the word the statute uses is apply property, which I've changed here. So bear in mind, this is a lot of what's in this is my interpretation of what I think the statute means, because there is a certain lack of clarity in some places. So a person who is appointed to preserve, protect, or use the property for the benefit of the person under the guardianship or conservatorship while the conservatorship is pending, or to assist in implementing other protective arrangements. We also have the temporary substitute guardian or temporary substitute conservator, who's a person appointed under the act for up to 6 months. So for a certain period, if there's a proceeding to remove a guardian. And as I said before, all of this is going to require more clarification by the courts or the legislature. Now, I referred to the organization of the Uniform Act, and it is well organized. So it has 7 articles in Washington. Now, the Uniform Act only has 6 articles, but as it's been adopted in Washington, we also have certified professional guardians. So we have Article 1, which has the definitions and jurisdiction and so on. Then we have Article 2, which is guardianship of minors, and that's effective right now. And then guardianship of adults in Article 3, which is effective January 1 of 2022. And then conservatorships of adults, which was the guardian of the estate before. And it's similar to what we have now in many ways, but in many ways it's very different and seems alien to older lawyers like myself. And I will say this might be the time, if there are younger lawyers who want to become experts in an area and want to study this new act, when there's a big change in the law, that's a time when new lawyers can step in. I don't know if anybody hears my German Shepherd barking besides me, but he's out in the yard next to the window here in the room I'm occupying. Then Article 5 talks about other protective arrangements, things that can be done to avoid a guardianship or lessen the restrictions in a guardianship. And as I note here, this is not effective now. And so minors who may need a guardianship may not have the ability to have the court consider other protective arrangements, at least as they are in the statute. Article 6 talks about forms, and I mentioned the form that talks still in the letters of office, still talks about guardianship. And sorry about the asterisk, but they are available now for the old guardianship under 1188 and 1192 on the website for the Office of Administrator of Courts. And I know they are working on and may already have forms for guardianship of minors. We will see. And then Article 7 talks about the duties of professional guardians and seeks to bring into the Uniform Act some of the statutes that governed professional guardians before. So now, and this may be something that's of interest to anybody that has a child who is close to 18, or they have a matter where a non-parent thinks that they should be taking care of a child. This is effective now, and it completely repeals and replaces the part of our statutes that used to deal with non-parental custody. So if a grandparent or aunt or uncle or really interested person thought that a child was being abused or neglected, or that it was in the best interests that the parent not take care of them, or maybe there were no parents. I've had cases in the past where both parents were killed and left children that needed to be cared for by a third party. So in Washington, our statutes now, the legislature decided that instead of having custody, child custody actions, that instead we will have this guardianship of minors imposed. And as I say, the old now non-parental custody statute contains a significant body of law, lots of cases, and the statutes have evolved over decades in order to try to decide what is in the best interest of a child. And that has become the standard. What is in the best interest of a child? And really, a massive amount of work has been put into the cases interpreting the statute and what notices need to be given. And the statutes have been revised many times. In the past, we would do guardianships of minors, particularly if there were no parents. If somebody had been taking care of a child and they might be turning 18. So once they turned 18, there would be privacy concerns, and those children might not be able to waive their privacy concerns without having a guardian. Wouldn't be able to waive them in advance because until they reach 18, they don't have the legal capacity to do that. But the point here is that we didn't have very many minor guardianships, but we have hundreds and thousands of third-party custody cases every year. And now all of those cases are going to have to be decided under the new Guardianship of Minors Act. And how that will mesh with all of the case law that we have now will be interesting to watch. So if you are a grandparent, aunt, or uncle, or just very interested party, the new law, if you bring a third party now Guardianship Minors Act case, you're very likely to end up in the Court of Appeal or the Washington Supreme Court. So under the new law, guardianship of minors, how do we decide appointment of a guardian? Well, a person, first of all, now will only be able to have the right to help a child officially if they've been appointed by the court. Up until now, parents have been able to sign custodial agreements. They've been able to temporarily allow for someone else to care for a child. Maybe you're sending a child across the states or into a foreign country with a custodian. We're not going to be able to do that anymore. You must be appointed by the court in order to be the guardian and have the legal right to help a child. How this is all going to fall out will be interesting. The court can appoint a guardian for a minor if the court finds that the appointment is in the minor's best interest, but then in addition, each parent of the minor has to agree, or all the parental rights must have been terminated for both parents, or maybe one parent is deceased. And then this is, or there is clear and convincing evidence. So a new standard of proof, a higher standard of proof, clear and convincing evidence that no parent of that child is willing or able to exercise their parental function. And then we have a reference to RCW 2609, seeming to bring the domestic relations law back into the new Guardianship Act. And again, it'll be interesting to see how that is applied if someone gets to letter C there. And it will happen, of course, sometime. Notice, what notice needs to be given? Well, the petitioner has to serve notice of the time, place of the hearing with a copy of the petition on the minor, if the minor is over 12, and each parent of the minor, or if there aren't any, their nearest kin, and any guardian who currently has non-parental custody under our old act. And finally, any other person the court determines ought to have notice. So you may end up giving notice to a lot of people. The court can waive the notice as long as there is good cause shown that giving notice to the minor might cause a risk of harm. And I guess that would include psychological harm. The court is prevented from granting a petition for guardianship of a minor if they haven't given proper notice. And bear in mind, I'm just giving little snippets here of the act, and there may be many ways in which someone might not give proper notice. So important to consult counsel about anything having to do with the new Guardianship of Minors Act. The court is not required to appoint an attorney to represent a minor, but they are asked to do that if the minor requests it or it's recommended by a guardian ad litem that the child have counsel, or the court determines that the minor needs representation. Now, contrary-wise, the court must, according to the statute, must appoint an attorney to represent the parent of a minor if it's subject of a proceeding where the parent has appeared and the parent is indigent, and either the parent objects to the appointment or the court determines counsel is needed to ensure consent to appointment, or the court determines that the parent needs representation. So, as far as the minor is concerned, the court is not required, but is given permission by the statute to appoint a lawyer. But the court is required to appoint an attorney for the parent of a minor under certain circumstances. Now, here's the question. Will the court appoint a lawyer? This is a brand new section of the law, and courts that have to pay for a lawyer may be put in a very difficult position. And for example, only in Grays Harbor, we just got a letter from our court administrator that's, it starts out very nice and sets an hourly rate of $150 for persons who are representing minors or parents. But it then says, this is a direct quote, that the recent enactment of the Uniform Guardianship Act, which replaces the non-parental custody statute, provides for the appointment of an attorney. But again, this is quoting from the legislature. At this time, the legislature has not included any funding for superior courts to enable payment of these additional fees and costs. If the legislature does not correct this funding problem, the Grays Harbor County Superior Court will not be able to pay attorney fees. And the Guardianship of Minors Act also includes a court visitor, similar to a guardian ad litem now. And they're saying they're not going to appoint attorneys or court visitors unless the legislature gives us the money to do that. And I expect that many other counties, especially the smaller counties, are going to be in the same predicament. And then what's going to happen? Somebody is not going to have access to competent counsel. They're going to appeal, and that's going to be thrown into the arms of our state Supreme Court, I expect. Now, we've talked about guardianships of minors under the new act. Now we'll turn to guardianship of adults. And how are we doing on time? It looks like we have enough time to finish. So guardianship is what used to be called guardian of the person. But when we get around to January 1, 2022, that person will simply be called a guardian. We now have the AIP, but that person will be called the respondent. The person who lacks the ability to meet the requirements for their own safety or health care because they're unable to receive and evaluate information or make or communicate decisions. Now, importantly, the Act says even with appropriate supportive services, technological assistance, or supported decision-making. Now, we did not previously have statutory references to supported decision-making. And we had not mentioned technology in any detail, but throughout the new act, there are references to technology. And this may be a good thing, but it's going to require the petitioner and the court visitor and the court to look at whether there are technological devices or software that can be used in order to help the person who's going to be under guardianship to make their own decisions or take care of their needs or communicate. And it's further states that the respondent's identified needs cannot be met by a protective arrangement instead of a guardianship. So before a guardianship is instituted, the respondent is the people considering the respondent's needs are going to have to consider less restrictive alternatives, including supported decision-making and the use of technology. When will a conservatorship be granted? Well, a conservatorship used to be called the guardianship of the estate. Now we call it a conservatorship. And for a conservatorship, it's granted when an adult is unable to manage their property or financial affairs because of a limitation in receiving and evaluating information or being able to communicate their decisions, again, even with the use of supportive services or technological assistance, and again, supported decision-making. And then finally, a conservatorship could be granted if the adult has been kidnapped, if they're missing, detained, or unable to return to the United States. So they have to be unable to manage their property for some reason. And in addition, appointment would avoid harm or significant dissipation of the property, or obtain or provide funds that are needed for support, care, education, health, and welfare of the adult. And the adult's identified needs, again, cannot be met by a protective arrangement instead of a conservatorship or less restrictive alternatives. This is not so terribly different from guardianship of the estate of an adult as it is now, but it adds a number of other considerations. And of course, we've got some new people to talk about. We no longer talk about a standby guardian. There's the special agent who preserves or applies property while a conservatorship is pending, or a special agent who assists in implementing other protective arrangements in a guardianship, what used to be the guardianship of the person. Statutes notably do not provide any further description of the qualifications or compensation or duties, or whether a bond should be required, or potential liability for special agents. So there are a lot of questions that courts are going to have to answer before they appoint a special agent. There is also the temporary substitute guardian or conservator, who is appointed for up to 6 months when a guardianship is pending, or the court can do that on its own motion if it finds a guardian isn't effectively performing the guardian's duties. And there's also a parallel process for a temporary substitute conservator if the conservator is not effectively taking care of their duties. We also now have successor guardians and successor conservators. And as you might imagine, that's a person appointed after a guardian or conservator has been appointed. A new guardian or conservator can be appointed when the predecessor dies or leaves, and the successor guardian would have the same duties. The successor conservator would have the same duties as the original, unless those duties are changed by another order. What does it mean to have the least restrictive or to have less restrictive alternatives? Well, they do have a statutory definition for what that means. And it means that you're restricting fewer rights than would be restricted by the appointment of a guardian or a conservator. Now, when defining less restrictive alternatives, we saw earlier other protective arrangements, and the definitions section of the statute does not relate other protective arrangements as part of a less restrictive alternative. I hope you're not all swimming in these terms. I remember when we first started talking about these, how I felt, and I don't want you all to be either going to sleep or feeling like this is just way too much. All I can say is I didn't do this. I didn't ask for this, but here we are. And if you're interested in guardianship, this is what's going to happen. So the statute talks about other protective arrangements, but it doesn't relate that as a less restrictive alternative. Other protective arrangements might be your neighbor promises to come and check in on you and has a safety valve where they can call another official or a police officer or somebody if they're not able to attend to their duties. Or you have the person subject to a guardianship, and there are a group of friends who will help that person take care of their bank account and so on. Of course, the further you get away from an actual court order appointing a guardian, the more risk and the less safety there are. So these other protective arrangements, we're not sure whether they're included or not, but we expect that logic dictates that a less restrictive alternative would include some other protective arrangement that the person subject to the guardianship would benefit from. And I guess here's where I really want to talk about technology, but I found 31 references in the Uniform Guardianship Act to appropriate technological assistance or the use of technology. And that means that all of us are going to have to consider the use of technology in meeting the needs of a person subject to a guardianship, which is likely a very good thing. Technology, it's interesting to know that we now can have robot dogs, for example, in nursing homes who can become the friend of a person in a facility like that, or indeed an autistic child at home can sometimes benefit from a robotic person or animal, and that is going to increase. So what are other protective arrangements? Well, first of all, you only have other protective arrangements after a petition for guardianship has already been filed. So this isn't something that you come up with or get approved beforehand, but rather a court order has to be entered approving that protective arrangement that's going to be used instead of a guardianship or a conservatorship. Guardianships can be very expensive, can be very restrictive of the individual's rights, and can require an awful lot of court reporting and monitoring. And so another protective arrangement, if it's possible to approve a durable power of attorney for finances or healthcare or appoint, pardon me, I think Christy and I did that right on time. So durable power of attorney, a representative payee for SSI, for example, or employing a caregiver or other people who can meet specific identified needs, and then the court enters an order saying, that's okay, you can do that. And we're getting down near the end of my presentation. This is the third major part. So we've talked about the old law, we've talked about the new law, we've mentioned that it might be a good idea to avoid a guardianship for many reasons. So, how do you do that? How do you avoid a guardianship? Well, just as a kind of preliminary matter, if someone has a child who is about to turn 18, and if that child has enough capacity, it's a great idea as soon as they turn 18 to have them sign a comprehensive, durable power of attorney for finances and health care. And we're going to talk about that again, but make sure you see a lawyer who can make certain that that document is properly signed, properly notarized, and has the right provisions in it. You may also want to have the child or someone else appoint a representative payee. And we will talk about that in a few minutes. Or if financial management is the main concern and you meet the requirements for doing so, starting an ABLE account in Washington in the last couple of years has its own ABLE account rules and statute. Or maybe transferring assets to a special needs trust would be another way to protect a child or a disabled person. Or in your own will, you may want to have a protective special needs trust for your spouse or for a disabled child. Now, as to powers of attorney, we have a new statute in Washington. Well, I guess now I have to say a newish statute. When you've gotten as old as I am, then you tend to think of anything within the last decade as being very new. But in January of 2017, the new Power of Attorney Act became the law in Washington. That's in chapter 11.125 of the Revised Code of Washington. And I will say, I've not had too many cases under the new statute. Of course, we are drawing our powers of attorney to be consistent with the new statute. But there has not been nearly the controversy around the new power of attorney statute as there has been around the new guardianship law. Under the old Power of Attorney Act, all you had to have was a document in writing that the person creating the power of attorney had signed. So you had a piece of paper that listed some things and said who they wanted as their agent under the power of attorney. Now, it was still very important that the power of attorney meet the needs of the person making it. And I'm just going to say there are not forms out there that are adequate for a power of attorney in Washington. You can't get an appropriate power of attorney document off the internet. And I've seen some pretty horrible ones that have come through my office. So the power of attorney now can either be witnessed by two witnesses or notarized, but There are a lot of provisions in the new act that you cannot take advantage of unless it is notarized. So critical that it be notarized. In our office. When we do powers of attorney, we both notarize and have two witnesses, independent witnesses who are my employees, witness the power of attorney so that it is as acceptable to other people as it can be. You also want to make sure that a power of attorney is going to be effective when you most need it. And that's when you might be incapacitated, either temporarily or forever. So you need it to be what the law calls durable. So there's special language that you must use in order to make it durable so it survives your incapacity. Just as importantly, there are lists of things in the statute identifying actions that the agent cannot take unless he's given the power to do that. So unless your agent has been given written authority in the power of attorney to deal with bank accounts, to take care of annuities, to take care of real property, trusts, and a whole lot of other things. Unless that language is in the power of attorney, it's going to be ineffective. So my advice is have a lawyer do that for you. Don't risk your future on an inappropriate power of attorney. Also, in your power of attorney, and even under the new Guardianship Act, there are provisions that say that you can designate who you want to be your guardian in the power of attorney. So your guardian, or now conservator, you can put that in the power of attorney. And we generally say in the power of attorney for our clients that they want the agent that they have appointed. Now, we hope we're going to avoid a guardianship. A well-drafted power of attorney is almost always going to avoid a guardianship. But if for some reason that doesn't work out, then we say, well, then we want the agent we've designated to act as the guardian, to be appointed. So powers of attorney are really, really important. And it's something, frankly, that every adult should have. I wish they were easier to draft. I preach at continuing education programs for lawyers that there are no forms. I wish there were adequate forms, but the problem is that every person is different. Every person has different needs and desires and capacities. And so these documents should be individualized to the people that sign them. So that's just a heads up. So in addition to powers of attorney, if someone is disabled, they can have a representative payee. And if they are of very modest means, this might avoid or severely limit what a guardianship would be necessary for. So the Social Security Representative Payment Program provides for the appointment of a representative payee. It has to be a suitable representative, and that person manages payments on behalf of beneficiaries. Now, in the past, even though you were the representative payee, it was kind of cumbersome because every I will tell you from experience, I had an incapacitated brother. Now, he has passed away, but under the program, I was his representative payee, but I had to make pretty cumbersome reports. I will say that I think that the reports have gotten better, but these annual representative reports, the law has changed so that there are some folks who do not have to make the report if you're a natural or adoptive parent of a minor child who resides with you in the same home. And interestingly, if you've been appointed the legal guardian of a minor child, you're not going to have to make those reports. If you're a natural or adoptive parent of a disabled adult, so you're the parent of a child who is disabled, and that's the reason they're receiving their Social Security payments, then you don't have to make these reports. Or if you are the spouse of a Social Security beneficiary, you can be the representative payee and not have to make that report. Now, there is an important caveat to that, and that is Social Security might come and ask you, are you really properly taking care of this person? Why would they do that? Well, they might do that because a nasty neighbor has made a report to Social Security that they think that you're using the disabled child's payments to buy your Rolls Royce or some other bad thing. So they get a report, but they might come and ask you for your records. So you do still need to make sure that you keep records. It might be something as simple as keeping the checkbook register or some other reasonable record. But you need to have those records so that if Social Security asks, you can produce them. So we've talked about representative payee. We've talked about durable powers of attorney. Let's talk for a few minutes about ABLE accounts. An ABLE account can be established if someone has either a disabling condition or they became blind before the age of 26. There's been a lot of talk about raising that age, and we may see in the current administration the usual age that's been mentioned has been 65 to bring this into agreement with a lot of other statutes in the Social Security realm that use age 65. But right now, as a matter of federal law, you must have developed your disability or blindness before the age of 26. That means you cannot be older than 25. But if you meet that condition and you're a citizen, you have to be a citizen, and to use Washington's program, you have to be living in Washington, Now, you don't have to use Washington. For quite a while, Washington had a program, and then they let that program lapse. And the federal law says that you can use other states. I expect that as this program grows, and it will grow because there's such a need for it, as it grows, it will probably be something where each state will start to limit who can use their program. We'll see. But in addition to having disability before age 26 and being a citizen, you either have to be eligible. Now, it doesn't say you're receiving, but eligible for Social Security, supplemental security income, or Social Security disability income, or experience blindness, or you can produce a signed diagnosis form from a physician saying you are disabled. Now, there are other little sub requirements to some of these, but that is the basic idea. So you can have an ABLE account if you meet those requirements. The money in that account, here's the great thing. If you're on SSI, you're not supposed to have more than, I'm sure you all know this, $2,000 in your account at any one time. And that's really, you're not supposed to have what they identify as resources. You're not supposed to have more than $2,000 in non-exempt resources. And as of the first moment of the first day of each month. But you can have an ABLE account up to $100,000. It supplements all of those benefits that you might receive. And you may have very important benefits. You know, besides SSI, you then may also be eligible for Medicaid, medical benefits, life-saving benefits. But now, in addition, you can have up to $100,000 in an account. Now, you're not supposed to be able to transfer more than $15,000 per year into an ABLE account. So you might have, I have clients that have special needs trusts that have much more than that, but they are fairly restricted in what they can use the money for. Not all special needs trusts are very restrictive, but on the other hand, many are. And it can be a real advantage to have the trustee transfer $15,000 a year from the trust into an ABLE account that is available for the beneficiary to be able to use it as they desire. And I know that it gives folks freedom, a feeling of freedom to be able to make some choices in their lives. So that money can be used for everyday expenses. It can even be used for housing and rent, which is completely contrary to what Social Security says about their SSI. Some items like education, housing, transportation, assistive technology, I list all of these things. Legal fees, really important. You can pay legal fees out of an ABLE account. Good. I think I saw somebody have a little laugh over it. You ought to get some laughter out of all of this. So Durable powers of attorney, appointing a payee, a representative payee, creating an able savings account. And then special needs trusts. So a special needs trust can hold money for the benefit of a beneficiary, and that money is exempt from consideration for that $2,000 limit for either SSI or Medicaid or any of the public benefit programs. And it can allow somebody to plan for the highest quality of life for someone who is the disabled beneficiary of a special needs trust. There are lots of different kinds of special needs trusts, and it's far beyond my ability in the time we have to even give much of a survey of special needs trusts. But we can have trusts that are made while both the trustor, person making the trust, and the beneficiary are alive, which we might call living special needs trusts. Or they can be in the trustor's will, where we call it a testamentary special needs trust. And we can even have trusts that are made by the beneficiary, made by the person who benefits from the trust. Generally, these are called D4A trusts because of statutory reference, which is the Title 42 of the United States Code, 42 USC 1396P D4A. D4A trusts can be made now by the beneficiary. We had the Special Needs Trust Fairness Act, or by a parent or a grandparent or the court. But for a self-settled or D4A trust, the person must be under age 65, and there are some other special requirements. There are lots of special requirements for the trust. They're complex, way beyond what, frankly, beyond what most attorneys will do, and should only be drafted by capable elder and disability law attorneys.